Here. Looks like we are going live here. Welcome everybody to this edition of Expert Witness with Doug Minor and Stephen Palmieri. We're coming to you live here. Looks like we're live anyway. And we bring this to you. Yep, we're live. We bring this to you every I guess twice a month to give you access to information and people that you would not really otherwise have access to. Doug Minor, my partner in crime over here,
Uh,
he started with credit. Well, no, he started with mortgages and then ended up with credit repair. And then now he is a bona fide or bona fide, if you're a Latin scholar, he is a bona fide expert witness. He sits back and helps lawyers help consumers. You've been in more court cases than we can count on these fingers. That's the only number you've authorized me to disclose to people to the 10th exponential power. So, Doug Minor, how are you doing today?
I'm doing,
Welcome aboard.
yeah. It's a great day. Excited to do the show today and talk about the courtroom and what we were talking about. It's going to be
Yes,
fun.
we are. For those of you guys watching, we do this for you guys. We are keeping an eye on the comments, so comment below. Really, we're doing this, for our audience here, CROs, and this is all about pre-litigation, which is all about, hey, how do you frame your disputes up and think from that legal profession, right? And Doug brings a certain level of experience and knowledge to us that we can definitely all learn from. And today we want to talk to you a little bit about, what is it like, because Doug, we were talking about what we're going to do for this show. And, we were saying, sometimes in our industry, people kind of like sort of flirt with the unlicensed practice of law, shall we say. They kind of like to write these letters and accuse people of breaking the law. And I'm like,
What?
dude, you don't know. I mean, until there's a judgment rendered, you don't know if, like literally, you have to get a lawsuit and then there has to be a judgment or a decision or a verdict that says your ass broke the law. Until that happens, it's just accusations, right? And I've seen cases go, very similar fact patterns. One judge goes one way and another judge goes the other way. And so there really is no way of, that's why we as CROs should never even worry about even thinking about the law. We need to find accuracies. But the thing we were talking about is, what you do, a big part of it, and with what attorneys do, is relationships, right? And that's what I talk about on the pre-lit side, is if you've got a power of attorney, you can use those relationships. You can call up debt collectors. You can try to get things deleted, right? At least, dude, nobody's really looking for a fight, right? If you call these people and you've got them checkmated, there's a decent chance you can get what you want. Not every time, but it's a relationship thing. And same thing with where you are, right? The attorneys hire you because they need a little extra heavy artillery, but you never know. It's kind of like a box of chocolates, right? You never know what to expect. Life is like a box of chocolates. Yeah, whatever. You never know what to get until you get in the courtroom. You don't know until you know which judge you got, and it can still go both ways. So let's talk a little bit about inside the courtroom, Doug. You could have this thing teed up. You could have like the most perfect, what do we call it? Expert analysis. You could have like the most expert analysis prepared. You could be like, dude, this thing is an ace in the hole. And then you sit inside the courtroom, and the next thing you know, things just go all squirrely. Let's talk a little bit about what are some of the things that happen in the courtroom, Doug, from your perspective as an expert.
Yeah, I think that's probably one of the more surprising things when you start doing expert witness work that you'll find when you're actually in the courtroom on a case and you're testifying. And I think we got to sort of set the groundwork, right? As far as what type of courtroom you're going into. Is it a federal court, a state court? Is it a plaintiff against a large company? Is it a family law case? Is there a jury? Is it a bench trial? There's all sorts of variables that come into play when you're going into a courtroom. And, when I remember back, I always think I think it was the first case or one of the very first cases I had was in federal court, which it's kind of, I kind of think of, like, you brought up Denny Crane, a law show when you
Good
go.
old Boston Legal, man. That was a classic right there. Denny Crane, because we were talking, everybody loves William Shatner as Denny Crane, and he said, he was talking to what's his name, David Spader. He's like, it doesn't matter if you're wrong or right. What matters is who can get the jury to like them the most. That's powerful.
Yeah, I think what an observation, or what a thought, right? Like, I think if you went into it thinking your likability didn't factor into the equation, I think you'd be mistaken. I think that your likability in the courtroom definitely, and your ability to communicate. But the point being is, like, depending upon what type of court you're going to go into, is if a federal court, in my opinion, at least in my experience, feels far more serious. The judges give the attorneys, again, all of this is sort of in my experience. The judges tend to, in federal court, in my opinion, tend to give more leeway to the questioning attorney, meaning they'll let them be maybe a little bit more aggressive with you as far as their questioning is concerned. Um, but then the flip side is, I've been in some family courts where it's a jury trial, and when you start explaining things, it's like you're teaching a class. I think that's how maybe the CROs that are in this group, or that are thinking about doing it. At least when I did credit repair, I did lots of speaking engagements, lots of classes, lots of first-time homebuyer events with realtors and mortgage people, and you were teaching. I there for, I don't know, about a year or so, maybe a year and a half, I believe. I did like training courses for first-time homebuyers at a local library, right? And so you have to learn how to teach these people what we're talking about. We as credit people, we can use our acronyms and shortcut conversations and so forth, but we have to really think in that mindset of, how can I best explain this so everybody's going to understand it? And you have to go into it with the mindset that they don't know about this stuff, or maybe they're at your kids level, at some age bracket, right? I was always told, like, right to a fifth grade level.
I think it's fourth grade. It's something like that. Yeah,
Some-
government websites are written to like a fourth or fifth grade level. Yeah, which is kind of scary. But in fact, with the time we're in now, it's probably a kindergarten level, if you know what I'm saying. It just keeps on getting worse and worse. So okay, so you sit in the courtroom, but so I'm sitting here thinking, and I mean, you're mentioning how federal courts are a lot more like serious feeling, and then you've got your state courts, then you've got like JP court, which is like what, under 10 grand or something. You could just roll up in your flip flops and like JP judges don't even need to be attorneys. That's kind of like just basically kangaroo court right there, right? Which, I mean, but you're never really going to be in one of those. So it's either going to be state court or federal court. And I'm sitting here thinking, well, pretty much your federal judges are appointed for life. I mean, so once they're there, the theory is that they can be kind of like unbiased, but state judges are basically glorified politicians. And I use the word glorified. They're basically politicians. I mean, because in most states, I don't think it's all states, but most states, they have to get reelected every term, state judges, And so, I mean, really, and I've seen it where it's kind of like, I mean, look, everybody's got a bias. Let's just be honest. I mean, nobody wants to say that, but everybody has some sort of a bias, and money does kind of talk in this world, and if you got things that are in state court, I mean, my point is, it's good to know your opponent, right? I mean, we would all like to think we're going to get a fair verdict, but I mean, it's kind of good to know the judges that you're going up against and kind of their political leanings, and also, I mean, kind of who's donated. I don't mean this to joke, but who's donated to their reelection campaign, because it may affect how not necessarily on your side because you're the expert, but the attorneys that are representing the clients, how they kind of pitch everything, right? I mean, let's talk about that. I know maybe you can't say much specifically to the facts of that, but I mean, from what you've seen from the attorneys, right? I mean, they kind of go in and you have to know your opponent, right? I mean, oh, this judge is like super conservative. Oh, this one's ultra liberal. Oh, this one kind of feels this way. I mean, you got to kind of know who you're going up against and kind of cater it to your opponent. Is that fair to say?
I think in the sense, there's a couple sort of things going on there with what you just said. So I'll try to address it this way. Knowing your opponent, meaning knowing opposing counsel and the opposing expert, or you've seen their report, or you've seen their rebuttal report to what the work that you've done as an expert, and you're going into a courtroom. So you already have good idea as to what their position is and what they're going to say. I always was taught it's you can anticipate, let's say 95% of the questions that may come your way, but it's how you handle that other 5 or 10% of the questions that you weren't prepared for, that sort of are a bit of a surprise, right? And so the courtroom itself and the judges, it's a very surprising thing. It was, at least to me in the beginning, because there were cases that I thought, oh, for sure they're going to win, from the fact pattern and the documentation and the information that I had been given. I could see no way that they wouldn't win, right? And sometimes it would come down, and it would come down the way I thought it would, or close to maybe what I thought it would. But there's been other times where I've been like, how did that person lose, or how could that other side have won with this sort of documentation? And so I can't speak directly to those verdicts as to, what or how was going on with a judge or a jury at that time. But I think as experts, we have to stay in our neutral position, look at it objectively, look at it from both sides, and give our best expert opinion about a situation. Now, to your point, bias or sides of an opinion, we're all going to have our own sides, and we're all going to have our own background, and we're all going to bring our own stuff to it. And so, like we've talked about on the show, John Olsheimer and I have been on opposing sides of each other many times. And I think, and we can respectfully have different opinions about a situation. And his background and his skill set coming into it's different than mine. Right. And so,
right.
And so judges, we're all human beings. We're all human beings. That's the point. And we're all going to come in, like you said, with biases or different opinions or different backgrounds and evaluate things differently. So be prepared to have I've had situations where one of the more recent cases that I testified on, it was done via Zoom, not in a courtroom, and the judge was directly asking me questions. Neither of the attorneys were asking me questions. It was the actual judge, and he was wanting to get a better understanding of certain reporting or certain impacts of things that he wanted to do to help make his own decision about the case. And so right now I'm actually waiting to hear back and see how the judges ruled and see how it goes. So it's a crazy thing. I always tell this one story that I found that, well, I'll tell you one of my stories. I was testifying in a case, and after, I think the questioning was there was some transition in the questioning between the attorneys. There was sort of a little bit of a pause. And during the pause, the judge leaned over and started asking me questions, more on a personal want-to-know basis, nothing to do with the actual case that I was testifying on. And this is all going on in front of a jury and the attorneys and the plaintiffs and everybody. And he and I are having a conversation while I'm on the stand, which always struck me as like, I just was like, wow, like this is actually happening. He's asking me questions about stuff that don't pertain to this case, but he wants to know stuff. So, I mean, and I remember that particular case, I felt very strongly that the side I was on would win, or at least it would rule in their favor. And I found out later that it didn't. And I was like, how's that possible? So judges are people too, the juries, everyone's going to have their own stuff and their own knowledge. And you just have to accept that. But the likability part of it, I think that's a big component. Well, maybe it's not a big component, but likability is part of our life, right? I always have taught my kids, the more likable and just, be friendly with people, be nice, be cordial, try to do your best, right? Yeah. And hopefully, and I remember even my kids, when they were younger, I took them into a store and I was talking to a woman behind the counter, and she ended up giving my kids free cookies. And I remember, gave my son a free cookie, and he came home and told his twin sister, he's like, Holden, you're not going to believe it. Dad was nice to this lady and she gave us free cookies, right? That's sort of a metaphor for, life, right? If you're nice, good things can come your way. I think you can get there's some of that's going to come into play in a courtroom, I think.
If you give the judge a big briefcase of cash for his re-election campaign, he's going to give you a free cookie. That's what I'm hearing. I'm just joking with you, Doug. I'm just joking with our audience. This is for entertainment purposes only. We've got that disclaimer in here. There's nothing in here.
Yeah.
It's intended. It's like South Park. They've got that little disclaimer at the beginning of South Park. All characters, even though they look and are named exactly real, are totally just coincidental. All right, so. So the judge, the attorney comes, they hire you. You've got to sit in front, sometimes you got to sit and give testimony, and you've got to defend your position. Sometimes, like you're saying, the judges look at you and ask you questions and stuff. Sometimes you're like, dude, this thing is going to definitely go one way, and it goes completely the other way and stuff. And so, what can you do to try to let's kind of hone this into our audience here, which are CROs, because our CROs, we're all about pre-litigation, which means we've got to kind of know what we're doing. We've got to be able to try to play the game of leverage. Then you get to litigation, which is the attorneys and they're representing the clients. I mean, what do these attorneys do, like when they hire you? I mean, what kind of things can they do to try to minimize the landmines of these things just going completely south, right? I mean, obviously, when an attorney takes a case, you would think they would feel pretty strongly about it, right? And so, what kind of things do you see that the attorneys do? And like when they see that it's going kind of squirrely and sideways, I mean, let's talk about how the attorneys could try to keep this thing on the tracks when it's not looking in their favor.
Yeah, all right. So a couple of things there. So first and foremost, you as the expert have to take it upon yourself to make sure that the attorney will spend an appropriate amount of time with you prior to the trial. Go over the questions that he thinks are going to come up, where he thinks the other side is going to question you on, how he thinks they're going to question you. And I've always taken a tact, or my position has always been, I'll go through things like that with the attorneys and take their advice and listen. And that's them just prepping you. That's you as the expert need to make sure that they'll take the time to prep you prior to walking into the courtroom. I don't want the CROs here. I don't want them to think like, you're not getting supported or you're not going to get prepped. You make sure that that's part of the working arrangement that you have with the attorney. So that those types, you can feel more comfortable. You can feel walking into a courtroom and the questioning that's going to come. As far as, let's say, while you're in the courtroom and you're testifying, and you said the word going sideways, I guess when I hear that, it's sort of, you'll hear objections to certain things, right? So you have to have this ability to wait for the question to be fully asked, pause for a moment, see if your attorney that's hired you object or not object, and then answer. If they haven't objected to it, then you can go ahead and answer. But sometimes they're going to object to a question or the form of the question, and the judge will either say something to the effect of, rephrase the question, or it's a compound question, and the opposing attorney will come back, and the question will be similar, but it'll be rephrased. So you really have to pay attention to those little things that are happening. It's like you're saying, there's these little battles that are actually going on right in front of you that you have to be aware of and be patient with. And I think sometimes that's why, like you see me here on the show, I try my best to not say anything over anybody, because that's a big deal in courtrooms. You can't, especially for a stenographer. Think about it. Two people can't talk at the same time.
Sometimes you want to just screw up the stenographer on purpose just to mess her game up. Or I say her, or maybe it could be a him, mess the stenographer's game up. But we've got Robert Sigmund here. He says that your shirt is much cooler than mine. So, Robert, I mean, if that's what you're getting out of this, then you're getting exactly what you're supposed to. Great work on that one, buddy. So Robert Sigmund, he's got a cool company called Kredzu that does escrow. If you guys are wanting to run escrow payments to legitimize your business, Look, he's got the little smiley face like that. Look at that. There you go, man. So appreciate you for watching. There we go. So give us a real question, Robert Sigmund. Robert actually, that dude is like gone all in on the history of the TSR, the telemarketing sales role, more than anybody else I know. So we need to get Robert on one of these shows actually as well. Let's see, enjoying for sure. Thanks for the info. There you go, man. That's why we do this. I mean, it's not every day we get to hang out with a bona fide credit damages expert witness extraordinaire, and that's exactly what we're doing here. And you just have to put up with me in the meantime to get to Doug. So, all right, Dougie. So let's get back to business here. So, what?
Go for
it. You put together this amazing expert thing. You look at the facts, and the case just totally craters and stuff, man. Like, what happens when that happens, man? I mean, does the judge look at you and they're like, I mean, does the attorney look at you and like, Jesus, I got to still pay you? I mean, what happens when this thing just falls apart? Let's talk about that.
Well, first and foremost, there's no recollection of a case just falling apart in a courtroom in front of me, right?
Okay, well, that's good. That's a win.
Yeah, actually, it kind of brings to mind, you were asking me about story. Like, gosh, I have so many stories about being in the courtroom, and the one that comes to mind, like, and I think this is to your question, right? It was a family law case. It was, I was on the side of the doctor spouse, and the opposing spouse was a homemaker. And how am I going to say this? Said that she didn't understand. I'm going to say him or her. I'm sorry. I was on his side, her side, the wife's side, the spouse. She claimed that she didn't understand English. And she went into the courtroom pro per, meaning she was representing herself. And on top of it, she had a translator there in the courtroom. So I'm representing the doctor, his attorney's there, I'm there, the judge is there, and it's just a bench trial, but it's in a big fancy courtroom I forget where it was, but it was a big fancy courtroom. And the 5 of us or 6 of us are in the room. And I was explaining what the spouse had done and missing the payments and how it had affected this guy's credit and that he couldn't buy a house and so on and so forth. And when it came time for the cross-examination by this woman who was representing herself pro per, she would say, she'd say the question, I think it was Korean. The translator would then ask me the question. And I remember one thing in particular that I found just dumbfounding. Her question was, it was sort of a question as a statement, right? A statement as a question. It was, well, he's a doctor, so his credit doesn't matter. That was her whole defense. Like, he's a doctor, so his credit doesn't matter. He gets whatever he wants because he's a doctor. It was just this like overly simplistic, naive. I don't even know. I mean, I can't speak for this woman, but talk about a case going like sideways and watching it happen in a courtroom right in front of you. I was just like, wow, this is unbelievable. And
that was good so it went sideways for them, and it helped you, didn't it?
Okay, that's the thing, Stephen. You when you say stuff like it doesn't do anything for me, right?
No, I mean, your attorney. You know what I mean? Like your side, the side that you were on, is what I mean.
I was on was happy to see what was happening.
I guess what I'm saying. Yeah, I mean, not you per se, not like you're going to get a bonus or anything, but I mean like your side. She was on the bad side, you were on the good side. And the bad side was crashing and burning, is what I'm really just trying to say here. But somehow I'm not really clearly using my words correctly. Now, you said pro per. What's the difference between pro per and pro se? I thought pro se was when you represented yourself.
You know what? Maybe you got me on that one. I'm not an attorney. Pro per, pro se, pro se. I don't.
She was representing herself anyway, is what you were saying, huh? So she didn't have an attorney, huh?
She did not have an attorney. She represented herself. And it was, but her husband told me that she knew English. She spoke English.
Yeah. Well, she had amnesia all of a sudden, huh? She somehow lost the ability to comprehend English, except to be able to understand, but go through the interpreter. So, All right. So for those of us listening here, again, we're all doing, credit repair, and it's a game of leverage, really. I mean, especially if you're doing it pre-lit style, and that's really the kind of the tie together here with what Doug does and with what we do, and why we bring this show to you. Because, I mean, with Doug, what you have to do is you have to take a look at the facts, and you have to judge the facts, and you have to formulate an opinion, and you have to write down your opinion, and you have to be able to back up your opinion with some sort of authorities and like factual things. And a lot of people in our industry, they'll just get this little software and they'll just push a button that says, not mine, never late, or something like that, which has like absolutely no authority behind it and no fact behind it, and probably not even true. And people wonder why they get bad results or why they can't go anywhere. And so that's really the tie together, right? I mean, if we can take a look at our client files and act as if we're a Doug Minor, I mean, what is wrong with the file? How can we put our enemy, our opponent, which is the credit bureaus and the furnisher, put them on notice of the actual errors? I think we may find that, again, you're not always going to get the results you want, but you have a lot more options after that dispute period, right? Because if you formulated a well-formulated dispute, then, and you can take a look and see which ways that they didn't comply, did they not fix it? And I think that's the toughest thing, is for people to just actually find the errors. And it does take time to put good letters together and stuff. But I mean, it's not like an attorney is going to come to you and just be like, Doug, I got no idea what I'm doing. I need you to build my case for me. The case is already built. They've already looked at everything, and you're just there to kind of strengthen it. Same thing we should be doing. We should be interviewing our clients, finding out what went up wrong. And then, I mean, if they just basically just blew their stuff up, then that's cool. Okay. But understand that we've got a job to do. So we need to find the errors for them. Hopefully we could try to find them some damages, right? Because if you're wanting to really send this thing to an attorney, damages are going to be kind of important. So we need to just kind of act as if, we're like the expert over here, and put good pre-lit letters together that can get our clients leverage. So let's see, we've got Robert Sigmund here. Serious question. Has pre-lit plus lit resulted in creditors or bureaus tightening things up, or do they remain just as vulnerable, error prone? Okay, so I mean, so I've been doing this since like 2009, 10. I've had my first clients litigate in 2012. I mean, the only thing that I see that changes them is when there is some super duper major precedent or a government action. I mean, honestly, there is so little. It's such a teeny weeny little. Let's see, remain. Okay, yeah. Do they remain just as vulnerable? I mean, I don't think that the bureaus are vulnerable. I think the poor consumer is vulnerable. I think the bureaus are definitely not vulnerable. They got more money than God. But I mean, I hear this. It's a good question. From my experience, I don't think that the few pre-lit people in this world, like Steve Jobs. Remember Steve Jobs with Apple? He said he wanted to make his little dent in the universe. You remember that? So I think we're just making our little dent in the credit repair universe. I think it's such a big universe that the things that we do are really insignificant in the big picture of the bureaus. They just wait to get whacked really, really hard. What do you think about that, Doug? And maybe we can finish this thing up on if you've seen anybody get whacked really, really hard over the head, because that is really where which it's a good question from Robert Sigmund. Look, squirrel, Doug, like I was giving it to you and I just took it back. I'm like an Indian giver, because we're talking, with Robert. Robert's all about TSR, and man, we're having all sorts of conversations about that, aren't we? Like, how do we fix TSR? And the regulators are trying to whack some people over the head with TSR to get their point across. And so what do you see, Doug, as we kind of wrap it up, man? Do you see, I mean, what do you think about his question? And then have you ever seen any really freaking huge whacks over the head in any of the cases that you've been in that have actually made a significant difference in the policies and procedures of any of these companies?
Yeah, as far as policies, procedures, or anything that, let's say, a large corporation has done because of one of these actions that I may be involved with, I have no idea. I I don't, maybe internally, maybe they change some policies or procedures. I'm sure that they go through that on a regular basis anyways, because a lot of when we talk about these large companies that end up in court on these cases, they're publicly traded companies, and they're, who knows, is there 10,000 employees, 30,000 employees? So yeah, as far as policies, procedures, and things like that, I'm sure that they're reviewed. I would assume that they're reviewed on some sort of basis, but knowing anything directly, absolutely not. But I think the takeaway from today is that, look, if you're on a case, when you get a case and you're going to go into a courtroom, make sure to communicate with the attorney who hired you. Make sure that they give you at least an hour to prep you ahead of the trial, and understand that you're there to educate. And like you said, I like what you said there earlier. Yeah, you have your opinions. You can back up those opinions, and you want to be able to just try to learn to communicate that as simply and as clearly as you can, so that a judge and a jury they're understanding the point you're trying to make and understand the opinion that you have about a situation.
Yeah, and I want to kind of add something. This is really a good point, Robert, with your question. I mean, and the things that I've seen, so, these companies, the credit bureaus, we'll talk about them primarily. I mean, they basically print money, and litigation is a part of their business model. And so they hire these really good law firms. I mean, but actually, even some of the lawyers, I mean, the lawyers don't even really understand the credit reporting standards. Because these lawyers kind of churn and burn. They work for these really big firms, but they hire these really big firms. Okay, so kind of my point is, from what I've seen, it's all about the game of lawyering. Like that's what their clients, which are their bureaus, they hire these law firms because they're like, we're going to pay you as much as you bill us. We just want you to lawyer. We want you to freaking just do your thing. And so that's where I think it really comes down to, they're going to have to get a big judgment or a government enforcement action against them, because they're going to win some and they're going to lose some. And when the lawyers get to lawyering, it's kind of like the Danny Crane thing where we're talking about, it doesn't matter if you're right or wrong. It matters who can make the jury like you. Well, even if you don't have a jury, the game of lawyering is an entirely different thing than what we would think it is. Like, you can have documents that are like the best documents in the world, but like, let's say you've got you sent a dispute document for your client. Now, I would always either do a power of attorney, or many of the ones that litigated my clients, I actually had them turned into affidavits where the clients notarized the dispute documents, right? So it's like a first party evidence. And I've seen it where, like, they can try to make arguments to try to get documents inadmissible. Like, I'm just giving you an example, right? Like the game of lawyering. And that never really happened in my cases because I just paper them up very good. But let's say you're just a regular credit repair company and you're just writing letters, which is kind of interesting. I know there's folks, there's lawyers who actually kind of want letters from credit repair companies that are not signed by the clients. But anyway, that's a whole other conversation. But on the other side, if they find out, hey, this thing wasn't signed by the client never saw it, well, judge, this is hearsay. We're going to throw this thing out. This is an inadmissible document. There can go your whole case. So my point there, I guess, is like, it's really interesting, the things that I've learned through my years, Doug, of seeing these cases. The game of lawyering, it is all about who can lawyer better, right? And when these things ultimately get to where they're either going to, and a lot of them honestly are going to settle, right? The majority, I think only like 1 or 2 or 3% end up going all the way through, Doug, right? So they're going to settle. Dude, that doesn't hurt the bureaus at all, right? So you got to think of the mass volume of mathematics here. So you're going to have a teeny percentage that makes it all the way through to getting a decision. How many of those are going to be painful enough for the bureaus to change their methods? So, I don't think there's enough fight going on to make it painful enough until the regulators get involved. What do you have to say about that, Doug? Kind of as we wrap it up here, man. David versus Goliath, so to speak, and then the game, the referee of the game and playing the game, man.
Yeah, it's an interesting topic that you're bringing up. I think as far as changing the big companies, none of us can speak for that, and it's not an area to talk about, really.
It's not for Doug Minor to talk about, because he's an unbiased, impartial human,
Yeah.
fallible, expert. So he's okay to make mistakes, but he can't make these kinds of mistakes, not on a recorded thing here. So, all righty. So that being said, man, Robert, I appreciate those questions. And for all of you guys watching us, we appreciate you being here. Again, we bring this really to you guys to give you some different information that you're really just not going to find out there in the rest of the credit repair world. And so, Doug, if people want to get in touch with you, I know you love mentoring. If somebody is interested in like wanting to become an expert, you're actually a pretty nice and generous guy, and you can mentor and train them. And how can people get in touch with you, Doug?
Yeah. Just so I do the trainings, right? And you can reach me at doug@dougminor.com. That's my email address, or just go to dougminor.com. You can hit me up there or call me, either way. And then just as a side note, before we wrap up, one of my students from one of my classes actually contacted me, got their first case, and I'm helping them through their first case. So I think that's another thing. Just know if you do this course and you really want to do it, after we're done, it's not like I'm leaving you to just flounder on your own. Like this case I just started helping another guy with. I'll be there to help you out. So
you'll flounder with them. Y'all will be floundering together. It'll be a group flounder thing, right? So the interesting thing about the flounder fish is both of their eyes are on one side of their body. Did you know that, Doug? Because they're like flat fish. I'm from Louisiana, so that's how I know that. We've got flounders down there. So, all right. And then for those of you guys, if you're interested in diving deeper on pre-litigation, we have our amazing pre-litigation training course, and it's a 30-day free trial, $99 a month. You can go to creditrepairtrainingcourse.com. More information there. And of course, feel free to reach out to me, message me, Stephen@StephenPalmieri.com. That being said, we will sign off on this episode. Thank all of you guys. Doug, it is always a pleasure, sir. And we will see all of you guys on the next episode. You all be good.